What happened?
Okay, stand right over there. Okay?
I'll tell you one thing. James N. Weigel is actually a misnomer, even though it's spelled in upper and lowercase letters. So he's really addressing the straw man.
Okay. Should I have said I do not understand, or should I kept asking you your name?
You were asking the wrong guy for the claim.
Okay.
You were asking the wrong guy's name. Okay? Because in a civil action, the bank paid a fee. Okay? He has to answer, and he has to pay a fee. If he doesn't answer, he defaults. Okay? Now he's got to go to court to get remedy. All right? So what I did is I just said, he hasn't appeared. If he won't give his name, he hasn't answered. He's pointing his direction at the judge. When I stepped in, I was waiting for you to turn to me and say, what's your name? When I stepped into back into the fray, when I saw what he was going to do, I then take over as a prosecutor, and I say, oh, I got this guy, because he's asking the wrong guy. Okay? You should have said to me, may I have your name, please? Okay?
Okay.
And do I have a claim against you? Okay? Blah, 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 blah,
Okay.
blah. Okay? So you want to try it again?
Okay.
Okay, so we'll just start over. Your Honor, I'm here representing National Bank of Massachusetts in this matter against Mr. Weigel, and we're asking for relief and damages be granted to the bank in the above referenced matter, as we are the creditor here, and that would be our motion to the court. Thank you.
Counsel, do you have documentation establishing your priority claim in this matter?
Your Honor, I'll have to check the file, but I'm sure we probably do.
Is James N. Weigel available in this court?
No, sir, but I am here.
And your name, sir?
How do I answer that one?
Well, just keep going.
What is your name, sir?
No, I asked you your name. Would you please state your name for the record?
I do not understand what you're saying, sir.
Well, do you know your name, sir?
I do not understand what you're saying.
Your Honor, again, I will make a motion that the defendant has not appeared, and that the bank immediately be granted summary judgment in this matter.
What is your name?
My name? My name is Sam Davis. I'm the counsel for National City Bank.
Do you have a claim against me?
No, I don't have a claim against you personally, no.
Does anyone here have a claim against me?
Well, sir, my firm has a claim against you, my client, National
Okay,
City
are they
Bank.
here?
Are they here? No,
Yes.
sir, I'm here on behalf of them.
Do you have a claim against me?
No, sir, I don't.
Does anyone here have a claim against me?
I don't.
Your Honor, my client has a claim, Your Honor, and we're going to ask again, Your Honor, for summary judgment in this matter.
Is your client here? I'd like the client to take the stand, please.
Your Honor, I'm going to object at this time.
Are you representing Mr. James N. Weigel?
I don't understand what you're saying, sir.
Well, you're speaking to the court in behalf of this summons and the complaint that's been filed with the court. Are you appearing for James N. Weigel?
I do not understand.
Is James N. Weigel in the court? The court makes the determination that James N. Weigel has not appeared on this summons, and consequently will grant the motion of the plaintiff in this matter.
Thank you, Your Honor.
Was that any better, or?
Well, it's a little better.
Still
You see, it's a little difficult, as she just said, it's real difficult to think on your feet. What do I say now? Okay?
When he starts to render the judgment, can he then say, I will accept accept that for value?
He could. He could say, he could also say, I object, and then the judge is going to say, well, who are you to object? Okay?
In other words, until he admits that he's somebody, he doesn't have any standing before the court.
That's right. See?
Can he ask if your claim is better than his?
He could, but he's got to come to court first. Again, he's got to answer and pay the fee. He's trying to get the judge to do what he wants to do, and the judge doesn't know who he is. He's not here. What the difference is, he's not here in a criminal matter. This is not an empty charge. This is a court of claim. There's a contract here. He's got to come into court because that's the only place he's going to get judgment. That's the only place he's going to get remedy. See, you're mixed up with, the only thing we've done here is we've showed you criminal type of things. Okay? And we're in a civil action. This is a claim for money damages or money, okay, in a breach of contract of some sort. Okay? So he's got to come into court, and then when he does that, he brings the judge his charge, I bring the judge my charge, and now the judge has something to work with. Okay? Now the judge is the holder of the obligation. Yes?
Why don't you reverse roles where you get over here and let him prosecute?
Well, we might do that in a few minutes.
Actually, what you should do is you be a prosecutor now, whether Joseph or something, so we can see it from both sides.
Well, yeah, but
I see what he's doing.
he's doing fine. Okay? I mean, you got to go through this. You got to, in other words, he keeps coming against that window. He's like that bug that he keeps hitting the windshield. Huh? Yeah.
To be able to get acknowledged by the court to say he's representing that person, can't he state his name in any way, shape, or form and just say he's representing and still be able to make his points then?
Well, what I would do if it was me, I would come in and I say, yes, I'm here in regard to that matter, and my name is such and such, spelled a certain way. Okay? Because they've sued me. Now, obviously, he's coming to court in this matter, and he's going to look at his remedy. Okay? Now, you've got to contemplate all the things that we've talked about here, and we've talked about a lot of things. Okay? Now, typically, if you were really going to go through this, you would then say, come up here, come and be the prosecutor. Now let me help him a little bit. Or do you want to help him? All right.
I feel like I'm being ganged up on.
You already said you didn't have a claim against him, so you were.
Okay, first of all, as Sam has pointed out, this is a civil action, not a criminal action. Okay, and what we have shown you here over the last 2 days is conduct in a criminal action. The first thing that happened here is that a summons issued on a civil action where a bank, which is a fictitious party, is coming against James N. Weigel. Okay? And the summons says that you are to appear and give an answer in 20 days. And it also says on here that you do not have to appear in court to give this answer. This hearing is moot. It actually would never even take place. Okay? That's the first misconception that's being given here. This would not take place under normal circumstances, because what would happen is the bank, the representative, Mr. Davis here, would be filing a default certificate with the clerk of the court, which she automatically signs and seals. And with that default certificate, the bank then obtains default judgment, seeking a signature and seal from the judge. And this is all done in the clerk's office behind closed doors within 24 or 48 hours of this 20 days exhausting itself. There would be the only time this would be going on, the hearing, would be in post-judgment proceedings, where the bank is simply attempting to now execute on what the complaint was originally. Okay, so we can first get that understanding
right
here. Okay?
That's very good, yes.
But just given the role playing that's going on here and what we're trying to learn. I guess, give me a clue what we're trying to learn.
Well, in other words, I didn't translate it the way you did. You're exactly right. I mean, he's got to give an answer, and we're in court about probably a month in advance of when we should be in court. Because
Well,
if he's given...
how about where he's at right now? He's in default.
Okay.
Let's be in a post-judgment proceedings here, okay? And he's now coming in. He's not coming in on this summons. He's now coming in under post-judgment proceedings where the bank is attempting to execute on his home, his car, his garnish his wages or something to that effect, okay?